Welcome everyone to our lecture on EU law. This lecture is divided into two parts. In the first part, I will discuss the nature of EU law, so questions like what is the EU, what is EU law, what are the sources of EU law, and what is the relationship between EU law and national law. Now, the answers to most of these questions will seem very obvious to you at first, but I want to show you that it's actually a bit more complicated than you might assume. In the second part, I will explain to you the different institutions of the EU, so the Commission, the European Parliament, the Council of the European Union, the European Council, the Court of Justice, and also the Council of Europe, which is not an EU institution, but I will make it clear why you should still know about it. Now, let's start with our first part on the nature of EU law. The first question we need to answer is, what is the EU? The answer to that may seem obvious at first. The EU is this international organization in Europe. It has 27 member states. It gave us these rights like being able to travel from one country to the other without border crossings. However, that is not the question I want to answer. Instead, I want to focus on the legal nature of the EU. Is the EU a state? Is it an international organization? Or is it maybe something different? Now, the first of these three answers, we can easily see that it is not true. We don't have a state, nothing like the United States of Europe right now. In the past, before the EU was even created, there were some people back in the early 20th century who had certain ideas of creating a federation of European states, but this never came to be. Some people still support this idea today, but there is currently no support for it from the majority of member states or citizens. What is the EU then? Is it just an international organization? One article that can help us answer this question is Article 1 of the Treaty on European Union. This article states, by this treaty, the high contracting parties establish among themselves a European Union, hereinafter called the Union, on which the member states confer competences to attain objectives they have in common. If you just look at that article, we see that the EU has a lot in common with other international organizations. It was established by treaties, it was created to achieve a certain objective. The only has the competences that member states explicitly granted to it. This is something that all international organizations have in common. The competences need to be granted to them by member states. And the treaties also set limits to what the EU can do with those competences. In this way, the EU is not different from other international organizations like the UN, for example. This idea that the EU only has power to act within those fields that the member states have granted to it is what we call the principle of conferral in EU law. You can find it in Article 5.2 of the TEU, and more details on which competences lie with the EU can be found in Articles 2 to 6 of the TFEU. For example, one field in which the EU now has exclusive competence, meaning that no power to act in that area lies with the member state anymore, is monetary policy, at least for those member states that are part of the Eurozone. Based on this, the conclusion we could come to is that the EU is an international organization, but a very advanced one that goes further and has more power than any other international organization. However, in reality, the situation is a bit more complicated. The law of the EU is much more integrated with the law of member states, and it is normally the case from classical international law. You derive much more individual rights from EU law than is usually the case with international law. Furthermore, the institutions of the EU have much more powers than is normally the case for the institutions of international organizations. For example, some EU institutions can bring proceedings against member states if they believe that those violated EU law, which is a very rare power to grant the institution of an international organizations. And member states have also given up more sovereignty to the EU than is normally the case with international organizations. Another indicator that the EU is something more than just an international organization is the fact that the EU has its own quasi-constitutional structure. So the treaties very much mirror what you would normally see in the constitution of a state. They lay down a division of competences between the EU and the member states, and this is comparable to what you see in federations, where the constitution will lay down which competences lie with the federal government and which with the states. Similarly, the treaties explain the composition and power of the institutions, which is similar to a constitution that lists the powers of parliament, government, the judiciary, and so on. There's also in the Charter of Fundamental Rights provisions on fundamental rights within the constitutional structure of the EU, which is again similar to constitutions granting individuals fundamental rights. Over the last decades, the constitutional elements of the EU have been strengthened, and in return, member states gave up some of the sovereignty in favor of the EU. Based on all of this, the conclusion that most scholars of EU law would come to is that the EU is not a classical international organization. It is something much more, something that you cannot really compare to anything else you have within the world right now, and that it is very much its own thing. The next question I want to answer is, what is EU law? We could give a simple answer to that. EU law is the law of the European Union. However, this question is more about the nature of EU law. Where does EU law fall within the Westphalian dual? Is it national law or is it international law? We can clearly see that it is not national law because we don't have a nation state here. However, it also doesn't really fall within the field of international law. EU law is more its own thing, its own legal order that binds the states, but also the different subjects within it. This idea that EU law is something more than classical international law was first formulated by the Court of Justice in two important judgments that were given in the 1960s. Now we are going to take a look at the sources of EU law. We have two types of sources, primary sources and secondary sources. Primary sources are those sources that have a quasi-constitutional value. There we have the Treaty on European Union, the Treaty on the Functioning of the European Union, and the Charter of Fundamental Rights. Now, if you need some orientation with the treaties and want to know if a certain issue is regulated in the TEU or the TFEU, a good guideline to go by is that the TEU has very general and basic provisions. It lays down the basic rules for the different institutions, for example, but does not go into much detail. And in total, this treaty only has about 50 articles. The TFEU, on the other hand, is much more detailed with several hundreds articles in total. And while the TEU only elaborates on the general rule, the TFEU then provides a detailed elaboration on everything about each institution or each competence of the EU. We also have three types of secondary sources. We don't talk about laws when it comes to the secondary sources in EU law. We have regulations, directives, and decisions. Regulations have a much more general application and automatically apply in each member state. So there is no need to transpose them into national law, and the legal situation will automatically be the same in each member state. Directives, on the other hand, need to be transposed into national law. This means that member states need to formulate their own law which has the content of the directives, but can find a way that fits most into the national legal system. Furthermore, they only give a certain directive, a certain result that should be achieved, but don't exactly lay down each detail. So member states have a certain leeway. Sometimes a directive just lays down some minimum rules, but member states can go further and they can do certain different things within the framework that is the same everywhere. Usually when we as individuals come into contact with EU law, it will be a directive that has been transposed into national law. The last secondary source we have are decisions. These only target individuals, not a whole collective. An example of that could be fines imposed by the Commission against Microsoft or Google, for example, because they violated EU competition law rules. Now, what is the relationship between EU law and national law? If the two are in conflict, which one prevails? The general principle here is the principle of the primacy of EU law. What this means is if there's a conflict between EU law and national law, EU law prevails. This principle was established by two important judgments given by the Court of Justice of the European Union in the 1960s. The first of these two was a Van Gent and Loos case. In this, the Dutch company Van Gent and Loos wanted to import chemicals from Germany into the Netherlands. According to Dutch law at the time, import duties had to be paid. However, the EEC treaty banned import duties. The EEC was a predecessor of what is now the EU. The treaty itself did not specify whether or not EU law had primacy over national law, which is why, while the primacy may today seem obvious, back then the judgment given by the court was regarded as very much revolutionary. The first important thing the court said was that the EEC treaty was more than a mutual agreement between the parties. For example, that the EEC treaty is not the same as a treaty between two states in which they agree to build a dam. Such a treaty would only lay down obligations for both states, but not have much of an effect on the nationals of each member state. And here the court said this treaty, it goes much further than is normally the case for treaties, which is comparable to what I said earlier about the EU not merely being a classical international organization and EU law not merely being classical international law. The court then continued and thought that EU law can be invoked by nationals before national courts and tribunals. What this means in practice is that if you feel your rights under EU law have been violated, you can go to your national court, and when making an assessment, the national court will not just have to take into account national law, but also EU law. In this way, the national judges of member states are also in a certain way EU law judges. Lastly, the court then explained that EU law constituted its own new legal order. So a legal order other than the classical law order we know of, and also that the subjects of this legal order are not that states, but also their nationals. So normally in international law, you would only consider a state to be subject of law, and this is not the case for EU law. The next important judgment was a judgment given in the Costa NL case. This case dealt with Italian law at the time that had nationalized electricity companies. However, the shareholder of the NL company, Mr. Costa, claimed that this violated the EEC treaty. However, this Italian law has been passed after the EEC treaty, and the question here was what happens if you have newer national law that violates the EEC treaty. Classically, in law, we say that if there's a conflict between newer law and older law, the newer law would apply. However, the court came to the decision that this was not the case here, and that EU law prevailed over national law, even if the national law was newer. The court confirmed again that the European treaties had created their own legal system and its own independent legal order, and then the courts of member states also had to apply EU law in their decisions. The court then made explicitly clear that EU law always prevails over national law, irrespective of the question whether or not the national law has been passed after or before the EU law. The reasoning for that was that if you had a treaty and would afterwards have national law that goes against this treaty, you could pretty much override the provisions of the treaty by newer national law, and the rights that were granted to individuals by the treaty would no longer apply. So now the situation seems easy, right? EU law always prevails over the law of different member states. This is definitely the position that the EU itself is taking. It's also the position that is generally accepted in the field of EU law. However, if we look at how things work in practice, the situation is a bit more complicated than that. In practice, the notion that EU law always has primacy over national law is a bit challenged by member states. Now, it is not challenged each time or for every rule that exists. States will generally respect the primacy of EU law over national law, but then reserve themselves a certain space where they think, no, here national law prevails. This would usually come into question when you talk about the question of having a conflict between EU law and the constitution of a member state. Take a hypothetical example. What if you have a mere directive that is in conflict with the constitution of a member state? Then some states would take the position that the constitution prevails over the directive. And different constitutional courts have at times also explained that they take the view that in a conflict between the constitution and EU law, the constitution should prevail. However, until recently, they have never explicitly made that clear in a judgment. They have hinted at it, but they have refrained from explicitly giving a judgment where they say, no, we as constitutional court say our law prevails over EU law. Unfortunately, this changed earlier this year in May 2020. The German Constitutional Court gave a judgment in which it made it very explicit that it took the view that the German constitution prevailed over EU law. You don't need to know the details of the case because it's very complicated. However, it was a situation in which the European Central Bank had taken certain steps, and there was then the question if the steps the European Central Bank had taken went beyond its mandate in the treaties and if the European Central Bank had gone too far. Now, normally, the Constitutional Court of a member state cannot assess whether or not a European institution acted within its competences. This is only for the Court of Justice of the EU to decide. However, the German Constitutional Court still said, no, we at the German Constitutional Court are going to assess whether or not the central bank acted within its competences. However, the German Constitutional Court went one step further. The steps that had been taken by the European Central Bank had already been reviewed by the Court of Justice of the European Union. But then the German Constitutional Court decided to review the decision that had been made by the Court of Justice. This is something which the courts of member states should not do. The final arbiter on EU law is always the Court of Justice, not the courts of member states. But the German Constitutional Court still decided that it had that power, and then went to so far as to say that the judgment of the Court of Justice did not apply in Germany. This created a direct conflict between EU law and national law of member states. There was a strong reaction coming from the EU, with some going so far to suggest that the Commission should start proceedings against Germany for violating EU law with that judgment. And now we have a bit this conflict between the primacy of EU law and the views of the courts of member states coming out into the open and becoming very much explicit. Now, does this mean that primacy no longer applies? The general view of the EU is still no primacy applies. This German judgment is invalid. However, there might also be a situation where now more constitutional courts might challenge the primacy of EU law. We don't know what the future will bring, but for now, the general principle should still be that primacy of EU law applies. At least this is the EU law perspective on it. Now we have arrived at the second part where I will explain to you the institutions of the EU. Now, before we start, one important thing, there are a few things that I'm going to explain to you where I describe things slightly different than they are explained in the book. The reason for that is that a few of the things stated in the book are slightly outdated. Most of what is stated there is still right. There are just two minor aspects where the situation has changed since the book has been published, mostly because of Brexit and because there were some slight changes in the treaty. The first institution I'm going to address is the European Commission. It has its seat in Brussels and is a bit like the executive of the EU. However, you cannot clearly compare the different institutions of the EU to national executive, legislative, and judiciary in its functions, in its tasks, also in its composition. So keep in mind that there are certain differences. The Commission is composed of different commissioners from each member state. However, they are supposed to be independent and not represent their member states, but the EU and Commission as a whole. According to the treaties, the number of commissioners should amount to 2/3 of the member states. However, we are currently still in a situation where there is one commissioner per member state because no member states want to give up on the prestige of having their own commissioner, so to speak. The tasks of the European Commission are laid down in Article 17 TEU. Firstly, the Commission is supposed to promote the general interests of the EU, so not the interests of member states, but of the EU as a whole. It also has the right of legislative initiative and, as mentioned earlier, acts a bit as an executive. Sometimes we also call the Commission the guardian of the treaties because they are supposed to watch over whether or not the treaties are kept, and they can, for example, start proceedings against member states if they feel that a member state violates EU law. Furthermore, the Commission also represents the EU externally and has something similar to ambassadors in countries outside the EU, and it also is a bit the face that represents the EU to EU citizens. The term of office for the Commission is usually 5 years, and we usually have a new Commission after there have been new European Parliament elections. The Commission is appointed in the following way. Each country decides on one person to propose as a commissioner. This is usually someone who has previously worked as a minister in a government. The Commission President then decides which portfolio to give that person. So the country does not know in advance which subject area the commissioner will deal with. And maybe they expect that that person is going to become the commissioner for finance because they have expertise in finance, and being commissioner for finance is a very prestigious position. But then this does not happen, and the person ends up being commissioner for something like digital environment, which would not be a very prestigious area to deal with. After the Commission President has decided which portfolio to give someone, there are hearings held in the European Parliament, and the European Parliament will vote on the Commission. However, it can only vote on the Commission as a whole, meaning they cannot say, we like this commissioner, but we do not like that commissioner. They have to approve the entire Commission. Later, it also has the power to dismiss the Commission, but again, it can only dismiss the Commission as a whole, and this never happened in European history. There is one special commissioner, so to speak, which is the President of the Commission. The President is a bit the head of the Commission, like you have a head of government in member states. It's currently Ursula von der Leyen. She has some special tasks, like appointing the different commissioners and deciding who will get which portfolio. She can also, after the commissioners have been appointed to one portfolio and the whole Commission has been appointed, make a bit of a reshuffle and decide, no, you are now going to deal with that subject matter, you're going to deal with another subject matter. She cannot dismiss individual commissioners. Again, this can only be done by the European Parliament. However, she can make it clear when she no longer has trust in a commissioner and pretty much force that commissioner to resign, which happened recently with the Irish commissioner, for example. She is also the one who lays down general guidelines for the Commission, the same way a prime minister would lay down the general ideas of government. And she is a person who represents the Commission, so the external face that you see most of the time in media when the Commission is discussed. Another important institution is the European Parliament, which is supposed to represent the citizens of the European Union. If you look how the EU developed throughout history, this is the institution that gained the most powers over time, because in the past it was only involved in decisions on the budget, and now it also has legislative functions, for example. And the idea behind that was a bit to strengthen the power of citizens in the EU, because there was often this criticism that citizens were not involved enough in the EU. The number of members of the European Parliament is currently 705. So this is one of the aspects where the number the book gives is a bit outdated, because the number the book gives you is a number that existed before Brexit, but now that the British MEPs are gone, we only have 705 MEPs. Elections for the European Parliament are held every 5 years. And how exactly that works in each member state is something the member state can decide by themselves. Now we come to the powers and functions of the European Parliament. It has power in the budget and needs to approve the budget. It is also involved in the legislative process. However, here the European Parliament is a bit different from the parliament of most member states, because it does not have the right to legislative initiative. This right lies with the Commission. However, it can still vote on legislative proposal. The European Parliament also has a bit of supervisory powers, meaning it can, for example, request different commissioners to come and answer questions about an issue. And of course, it also has to vote on a commission and has to approve it, or could even dismiss it. While a full-on dismissal has never happened, and the Commission can only approve the Commission as a whole. What sometimes happens when they would be really dissatisfied with one commissioner is that they could threaten to bring a vote to dismiss the entire Commission if this one commissioner doesn't step down. And this is then sometimes used a bit as a sort of threat instead of voting down the entire Commission. The Council of the European Union is often also called Council of Ministers, or just Council. I know we have different councils that we are going to talk about in EU law, but you should really remember the difference between each of them. The Council is composed of the ministers from each member state, but in practice, we actually don't have one council, but we have different councils with a different composition depending on the subject matter. So sometimes you will have an agricultural council with the ministers of agriculture. Sometimes you will have a finance council with the ministers of finance, and so on. The presidency of the council rotates every 6 months, and by presidency it just means that one state shares the whole debate. Currently that is Germany, but soon it will be another member state. The tasks of the Council are very similar to the tasks of the European Parliament. So it's also involved in the legislative process and in the budget, and these are tasks that both institutions share together. It also has a bit of a policy-making task, but over time this was a function that has been more taken over by the European Council. The Council has a bit of a unique voting system, namely qualified majority voting. In some aspects, also other voting systems like unanimity is used, but which majority is required will usually be laid down in the treaties. However, for most cases, the Council uses qualified majority voting. Now, how does it work? Well, we have a bit of a new system, which is why, again, this is the other issue where the book is slightly outdated. The rule today is that, firstly, in order to be approved, a legislative proposal needs to be agreed to by 55% of member states. That's 15 out of 27. And these member states must also represent 65% of the population. Why do we have this double requirement? Well, there is a bit of an idea behind it to represent both the states, but also the population. If you had a situation where theoretically it would just be enough for 15 states to agree on a certain issue, you could have all of the smaller states agree on it, but they together do not represent the majority of the population of the EU, the majority of citizens who are going to be affected by a decision. However, if you just have a population requirement, You could have a situation where maybe France, Italy, Spain, Germany, and then also Poland agree on something, and then the legislative proposal would pass just by having these 5 states agree on it without taking all of the smaller states into account. And we want to have both a representation of states and a representation of the population. The European Council is a relatively new institution. For a long time, there were these informal meetings between heads of state or government of EU member states. However, this was not an official EU institution, and the heads of state or government would tell their ministers in the council how to vote, of course, but they weren't really represented in any EU institution. However, this changed with the Treaty of Lisbon, which officially set up the European Council as an EU institution. It's composed of the heads of state or government of each country, so a prime minister or president. In addition to that, the permanent president of the European Council, as well as the president of the European Parliament and of the Commission, are usually represented. However, the last 3 cannot vote. Its main task is to set the general agenda of the EU, and over the last years it has also become a bit of a crisis-solving body. So right now, for example, dealing with COVID and deciding on how the EU should deal with the whole corona situation, how many aids should be given to countries, and so on. Actual voting in the European Council is rare, so most of the time they just try to reach a decision by consensus, meaning everyone agrees on it. However, there are some subject matters where they vote by QMV or unanimity. Again, this is in more detail laid down in the treaty. We also now have this permanent president of the European Council, whose main task is to chair the meetings, moderate the debate, try to find a compromise if the whole issue is really stuck, and also to prepare the meetings. The current president is the former Belgian Prime Minister Charles Michel. His term of office is 2.5 years, however, that can be renewed once. Our last institution is the Court of Justice of the European Union, but it's obviously the most important institution for the field of law. It's technically a bit like 2 courts. We have the Court of Justice, which is sort of the higher court, and the court that deals with the more important subject matters or with appeals. And then there is a general court, which is sort of the lower court and deals with sort of the less important issues that come up a lot of times, have maybe already been settled. The main tasks of the Court of the European Union are many, but the ones you should know are, for example, preliminary references. Now, this is a situation where in a national court an EU law question comes up, and this has not yet been answered. So the national judge sends a reference to the Court of Justice of the European Union and asks the Court of Justice a very specific legal question, and then the Court of Justice is going to answer that. This is the most common task the Court of Justice deals with. It also deals with so-called infringement actions. This is an action, for example, if there is an allegation that a state violated EU law, then the Commission can bring action against that state, and the matter is then decided on before the Court of Justice. We also have annulment actions. This is similar a bit to constitutional review in member states. So when there is an allegation that a directive or regulation violated EU law, proceedings can be brought either by one EU institution or also by member states to have that specific directive or regulation annulled. Now I'm going to explain one last organization to you, and that is the Council of Europe. Now it is not an EU institution. Why do I still mention it then? Because that is an institution that comes up a lot of time in the media, for example, or also in other courses if you decide to continue with law or do something European studies related. And there can be a bit of a confusion on what type of organization that is, which is why I want you to know what the Council of Europe is. It is an international organization, but concerning the region of Europe, and its aim is to promote human rights, democracy, and the rule of law in Europe. It has 47 members, so a lot of members that are not part of the EU, be it Switzerland or Iceland, but also Russia and Turkey. It's pretty much all states in Europe except for Belarus and the Vatican. And its most important institution is the European Court of Human Rights. So whenever you hear about the European Court of Human Rights, keep in mind that this is not an EU institution.